Using what Susan and Joe said though earlier, I think like you can, I analogize like the axe and the concept of talking with an accountant or a tax planner regarding business structure to what I hear this term used in a lot of other contexts. It's called due diligence. And I think if you're going to hire somebody, if you're going to do anything in your business, you need to take these steps, like the due diligence steps, ahead of time. It doesn't matter even if you're a consumer buying a car. I mean, you're not going to walk into a dealership and just take the first offer, the first thing that the salesman throws at you. You're going to do some research on the internet, whatever. So if you're going to hire somebody, if you're going to structure your business a certain way, do your due diligence. Look at what other businesses are doing. Look at what friends, neighbors, accountants, lawyers, whatever they're telling you, the advice that they're giving you. Vet it all out. You're going to hire somebody, a salesperson, whatever. Vet that individual. Do some background screening or checking, or make sure you're using a valid or justified interview process or selection process, whether it's a test, assessment, some sort of assessment instrument, whatever. So I think a lot of, and all roads lead back to profit. And I think the first street after profit, or first off ramp, is probably due diligence. So that's the one thing I could, if you're going to look at growing, that's the one thing you need to do relative to understanding what your business is, what your business's needs are, what your own needs are, and what your employees they're going to need, and what they're going to need from you. Also, I think what Susan brought up in terms of culture is so crucial in terms of not just, and I'm an attorney, so people tend to think that attorneys, everything is black and white. It's like you can't do this or you can't do that. Well, no, I mean, that's not the way I operate with clients of mine. My clients, we're small, medium-sized businesses. I'm a solo practitioner myself. I've been on my own for 11 years now. Some people say I have an entrepreneurial bent or orientation myself. And to me, I look at entrepreneurialism as being sort of like, running something by your gut, intuition. So obviously that counters, or it seems to run against the logic of what an attorney does. An attorney being very analytical, everything's got to be, diced out and, chopped up into its finer parts. And no, it's not always the way we operate, especially, if you're in court or something like that. You don't have hours to do research in front of a judge, while answering a question. So basically, culture is, even though it may run counterintuitive to the idea of like analytical thinking and law, it's really not. And statistically speaking too, culture is probably the biggest predictor of success on the job for any employee. And the reason I say that statistically is because this was actually done in research by the Jevity Institute, which was it's a professional employer organization that has its own branch, research branch, that works in conjunction with the Cornell University Institute of Industrial Relations. And they found in some research done around in the last 10 years that basically the biggest predictor of workplace success is culture, or basically personality. So which is why, Susan brings up when you're like a solo business person, a small business person, you tend to hire people that are more like yourself, because you think, if I'm running a successful business, I need people like myself in order to be able to perpetuate that success down the line. And there's some truth to that. Whether or not that's the best way of going about growth in terms of hiring people or not, that's debatable. It's really going to depend on what your, again, your culture, personality, your own interest, what you think is most important. Now, in terms of the due diligence, then, in terms of who you're going to hire or use, I would look at, or one of the first things I would consider is a job description. And I think in terms of, whenever I'm talking with a client and investigating the nature of a legal dispute, that an employee is suing them, or maybe they're getting shaken down by an employee's attorney, or they're dealing with some regulatory agency like the Equal Employment Opportunity Commission, I'm always going through the same analytical process. Not just what happened, but who is this person? What job were they doing? What were the key responsibilities and roles they were fulfilling? And in all honesty, more often than not, I don't see clients going through that process, this analytical sort of thinking in terms of what do I need to do, not just to hire somebody, but what am I hiring them for? What kind of responsibilities and roles am I going to be hiring them for? Is this stuff going to be, am I hiring them to do legal things, illegal things, ethical, unethical? Am I even classifying them properly? Are they an employee or an independent contractor? Can I just hire an independent contractor and then bring them on as an employee after 3 or 6 months or whatever amount of time? And these are things that I don't see enough of my clients going through. And I don't necessarily believe, I'm not the type of person that says you have to talk with an attorney before you do that. I don't necessarily believe that. There's a lot of information out there, that's available for free, and a lot of credible information that's available for free that business people can use. You get off the internet, there's a lot of different phone type operations, 800 type things, which provide the same sorts of services. So it's not that you have to, as a business person, automatically go to an attorney to get the answers to these questions. The answers are generally out there. Sometimes you need an attorney. I think when you really need an attorney is more of the execution of how to implement this stuff, as opposed to just what you can or can't do. So meaning, is this legal or illegal? Yeah, you can, like I said before, a lot of attorneys tend to look at things in black and white, what's illegal or illegal. I don't look at it that way. There are always ways of massaging these things. And one of the reasons I use the word massaging and kind of finessing your way into these issues or finessing your way through these disputes is that I deal with a lot of regulatory agencies, and these are supposed to be the experts on in their own particular law, like the Equal Employment Opportunity Commission. They're the experts in Title VII of the Civil Rights Act of 1964, and they're the experts with the Americans with Disabilities Act. There's so many times I'm talking with these individuals, investigators or attorneys at these agencies, and they don't know the way that the law is applied to the same circumstances that we're talking about, their same individual disputes. They don't always have the answer themselves. And if they don't always have the answer, how can myself, how can I, or any of you always be expected to have the answers? So you're going to encounter, no matter what, if you're growing as a business, you're going to encounter problems, and it's going to happen. So in my mind, if you do your due diligence in the first place and think in terms of culture, personality, and then also analytically speaking, to some extent, think in terms of the job, the job itself. What am I hiring somebody for? Do I need a job description? Have I done it? Have I thought this out enough? I mean, obviously, if you're running a 7-Eleven, you don't really need a comprehensive, or maybe you don't even need a job description period for a clerk or a cashier. But if you're running a highly regulated business, something in medicine, energy, whatever, then yeah, you'll probably need a more comprehensive or more well thought out job description. And also, frankly speaking, if you're hiring somebody and you don't know what you're hiring them for yourself, or you can't always answer that question, they got to be thinking, why do I even want to work for this guy? Because in my mind, any employee or potential candidate has to be doing their due diligence on you as an employer. And to me, that's just part and parcel of this whole common sense aspect of running a business.
I'm sorry, Troy, I had a question sort of on that, and it sort of stems with your presentation. Employment agreements, and you get a good employee, they come on board, you train them, they're producing, and then they decide like a year after, you know what, I could do this on my own, and start their own thing, and then they try and go after your business, right? Yeah. I mean, typical in a sales type job. I always hear that word reasonable amount of time, like as far as an employment agreement or something. Can you talk a little bit about sort of like what that means, reasonable?
Yeah. In fact, what I'll do is I was actually going to open up with this story, but I decided to change it around based on the presentations earlier, because this relates to an actual SBAC member. So I'm representing an SBAC member in a dispute with an ex-employee who went to work for a competitor of theirs. They're in both businesses are in the B2B market area, and I'm not going to get specific about what industry they're in. But what happened was, the genesis of the dispute is that this company, the SBAC member, bought another business out. It's about 2 years ago now, 3 years ago. They bought the business out. It was a family-owned business, maybe 5 employees. They bring 40 employees over to to their business, and they have them sign non-compete agreements, and in the buy-sell agreement too. What was interesting was that it specifically mentioned to the employees in the buy-sell agreement. The buy-sell agreement wasn't the best written agreement. It's not. I wasn't involved in that transaction. The employment agreements that they're using are also not the best written employment agreements, so there's some problems there. There was a 3-year non-compete clause in the employment agreement, and this was a salesperson, by the way, too. Yeah, 3-year non-compete. This was a salesperson, by the way, who he left the company, he left the employer, my client, after a year, goes to work for the competitor, almost in the same region, and is now stealing clients away from the business that the family member sold to my client. It's taking those clients, and also took an employee, took one employee who had some confidential information over to the new employer too. So what happened was, we started out in December, January of this year, making the phone calls, kind of doing my groundwork, the due diligence, saying, hey, you know, calling up, contacting the employee, contacting the employer, the new employer, saying, hey, this is going to, you know, can we work this out? Otherwise, this is going to mushroom into a whole dispute. For whatever reason, contact between us broke down, so we filed a lawsuit about a month ago, including asking for a temporary restraining order and preliminary injunction, and we're in the process of going through all this now, which is why I think this is a really great example, because this is all ongoing even as we speak. Last night we were talking about settling the case. I was talking with the two opposing counsels about that. So what happens is that I'm looking at this non-compete agreement that was originally signed by the employee, and this non-compete agreement indicated a 3-year restriction, and there was no territorial restriction. So there was nothing like saying you can't compete in Cook County, or you can't compete with these businesses or those businesses, whatever. Generally speaking, the law said, the law looks at 2 factors in these non-competes, and that's the time, how much time is going to be, how much time are they restricted from working in their business, their trade, whatever, and what are the regional restrictions. All right, so the time restriction was 3 years, but there's no indication why they chose 3 years. It turns out that they chose 3 years because that's the typical length of their sales agreements and servicing agreements with their customers. Fine, that makes sense, but it didn't say that in the agreement, and because the agreement also didn't have any territorial restrictions, it kind of leaves this vagueness to the, as to the enforceability. So now we're kind of like caught in this dispute with them that August 22nd is when we actually have the preliminary injunction and temporary restraining order hearing, so we'll know more on that date. But you know, right now we're all trying to figure this out. We're all having these debates with one another, trying to figure out, you know, why did you not go through the territory restrictions? Who's he selling? Who's this guy selling to? How much lost profit have you already incurred? And then also, what I thought was interesting, and I mentioned before, was that this guy was also written into the actual sales agreement. So there he is, he's mentioned in the sales agreement specifically that he has to sign an employment agreement and he's coming aboard. Well, according to my client, he was coming aboard, you know, in perpetuity, you know, could have been forever. But according to the former business owner who sold the business to my client, he only expected this guy, his family member, to come over for a year. So you have these factual disputes. We don't know how they're going to play out, but generally speaking, you know, 3 years I don't think is all that unreasonable for non-compete. I've seen doctors who've been restricted from competing against former, I'll get to you in a second. I've seen doctors, though, who are prohibited from competing against their former medical practice for 5 years. So I figure if you could prohibit a doctor in Illinois from competing for 5 years, why not in this industry for 3 years if that's what their typical sales agreements are? Hang on, Shirley. You have a question?
Well, I don't know if this is the right way to do this, but I've been through a couple of these things before, and right now with the economy the way it is and the way the world is changing, how strongly are judges ruling on these non-compete situations that can literally put a guy or a woman unable to feed their family for 1 or 2 or 3 years? I mean, is it loosening at all because of the economy, or not really?
No, it's not loosening at all. In fact, there's some legislation proposed right now in the state of Illinois, I think, to limit non-competes or non-solicitation agreements to a year. So, you know, where that's going to play out, I don't know. I forgot what the name of the law is, and I forgot who's sponsoring it, but I know it's in the legislature. But you're right. I mean, that's why I'm placing so much emphasis in my arguments about the buy-sell agreement, that the fact that they mentioned this guy's name in the buy-sell agreement, and that there was actually some additional money paid to him in the 5 figures that was actually given to him as a pass-through in the buy-sell, you know, for this guy to come aboard and not compete. That's why I placed so much emphasis on it. Oddly enough, my client didn't tell me about that, all that pass-through money and the buy-sell agreement until until just not long before we actually filed the lawsuit and temporary restraining order and request for injunction, because I was figuring prior to that knowledge, I don't think we're going to be able to enforce this. Judges don't like to enforce that kind of stuff. They don't like to restrict people from trade or from working within their industry. However, they understand that the businesses themselves have a interest in their customers, clients, intellectual property, anything that could be taken or improperly taken by or unfairly taken by an employee to a competitor.
Chuck, we could probably do one more, and then we'll have to pass it on.
Okay. Sure.
If I recall, I read someplace where a gentleman was working for a sports drink company, and he got hired by, I I think 7-Up, he had signed a non-disclosure. The judge said he couldn't take the job. This was a New York case. He said he couldn't take the job, and the judge didn't put a time limit on it. He said it wasn't possible for this guy to go to work for 7-Up as the president of a new drink they were bringing out in the same field without using the information he had from the other company. Non-disclosure beats a non-compete agreement all over the place. Or they ought to go together.
Yeah, I agree they ought to go together. And I don't know why the NDAs would be the non-compete. It could just be up to the judge, or or it could have been, in this case, the fact that it was a president of a company where maybe they're privy to more sensitive information than a typical salesperson or a general worker would be.
Salesman's got information on the customers. Why should why should you let him go carry all that information to the next place? You got to let him figure out how he can make a living. So maybe if you restrict to the Midwest territory or some reasonable territory for the existing business, the guy can go move to California and go to work, or he can move to the East Coast or someplace and go to work. But
you use the key word there, reasonableness, and it's a sliding scale. That's going to be contingent upon the factors of like time and territory. So,
Cool.
we're all done.
Thanks. Thank you, Chuck.